In a significant development for H-1B visa holders, a U.S. District Court has ruled that individuals can now contest their visa revocations if these are linked to employer fraud, especially in cases where they had no involvement or were not even notified about the issue. This groundbreaking decision emerged from a lawsuit filed by 10 Indian nationals who found their H-1B visas unilaterally revoked by the U.S. Citizenship and Immigration Services, USCIS, due to fraudulent activities conducted by their employers. The complainants argued that they were unfairly penalized without being given an opportunity to defend themselves, highlighting a substantial oversight in the notification process. The court acknowledged that the affected visa holders were left in the dark as USCIS sent notices of intent to revoke exclusively to employers, effectively sidelining the individuals directly impacted. According to reports, including one from the Times of India, this ruling is a significant victory for Indian nationals on H-1B visas, offering them a pathway to challenge unfair revocations tied to misconduct by their employers, not by the visa holders themselves. This case was presided over by Judge Chun in the Western District of Washington, who clarified that H-1B visa holders have the right to contest the USCIS's attempts to revoke their visas if they were not implicated in their employer's fraudulent actions and were denied proper notification. The judge emphasized the importance of due process, suggesting that affected individuals must be given a chance to respond to allegations prior to any action being taken to revoke their visas. This ruling comes on the heels of another legal action taken by nearly 70 Indians in August 2023 who sued the U.S. government over H-1B visa denials linked to former employers' fraudulent activities. They argued that their visa applications were unjustly denied based on their association with companies implicated in fraud, companies for which they worked in good faith and without knowledge of any illicit activities. Through this lawsuit, the plaintiffs are seeking a fair review of their applications by the USCIS, including the opportunity to counter any fraud allegations against their former employers. Furthermore, in response to the ongoing concerns about fraud within the H-1B visa program, the USCIS has announced several updates aiming to tighten the application and selection process for the fiscal year 2025 lottery. These include measures to prevent the submission of duplicate registrations for the same individual by different entities and proposals for conducting site visits for contracting firms, as well as a more thorough review of job requirements for third-party positions. This evolving legal landscape underscores the complexities of the H-1B visa program and the necessity for individuals to stay informed about their rights and the mechanisms in place for their protection against unjust visa revocations. For more details on this developing story and how it might affect H-1B visa holders and applicants, please visit visaverge.com.